Hello, my name is Sasha Struthers. I'm a landlord attorney here in Los Angeles, and I'm doing a quick video on emotional support / service animals for current tenants or tenant applicants. Before I go into that, you should subscribe to this channel. You should go to my website and subscribe to my newsletter. Both are free and both are very informative. So to begin, there's service animals and there's emotional support animals. Service animals are trained specifically to assist the owner with a physical or mental disability. And they don't have to have any certification. They don't have to be trained by anyone specific. They could be trained by the owner himself or herself. But they're trained to assist this individual with their daily life activities. And it doesn't have to be a dog, though typically it is a dog. Now, an emotional support animal is slightly different. They don't have to have any specific training, and they're there to comfort the owner with a often mental but can be physical disability. Emotional support animals, again, typically are dogs or cats, but they could be a different kind of animal. Both of them aren't limited to dog. When you get a tenant who has brought to your attention they have a service or emotional support animal, or you have an applicant who has one of these animals, you can't deny them based on this animal. So you can't prohibit the tenant from allowing the animal to live with them, and you can't deny an applicant based on this animal. That is discrimination. Additionally, you can't ask for an additional pet deposit because these animals are not considered pets. Now, the tenant is responsible for any damage that the animal causes to the unit, either move out or during the tenancy. And so that does get deducted from the security deposit or gets billed to the tenant. But you cannot ask for an additional pet deposit. Now, if you want to verify the legitimacy of this, there's not much for a landlord to really verify. You can't ask for medical records. You can ask for certification of physician's note or a letter from the case manager validating that this is a service animal or support animal, and you got to take it from there at face value. Because it's animal and not specific dog or cat, there's times when landlords get confronted with an obscure, I have an emotional support boa constrictor. That's not, I don't think I've ever had anyone come to me with that, but people get pretty out of hand with these animals. In that case, if you get something where you're not really sure or you're not comfortable with it, you should talk to an attorney. There are some exemptions for landlords, and it does deal predominantly with the safety of other residents in the building and potential damage to the property. But you want to talk to an attorney because it's, again, a gray area, and you don't want to open yourself up to a disability discrimination lawsuit in housing if you don't have to. I hope that was helpful and informative. It's pretty brief overview. If you have any questions, feel free to email me. My information will be below. Again, subscribe to this channel and my newsletter because you'll be informed at least weekly. Thank you.